Well, quite a surprising judgment came out yesterday. The Bloemfontein High Court judge, Phillip Loubser, ordered the lifting of an asset freeze on 250 million rand in assets belonging to the Gupta family. The freeze granted in April was on assets reportedly including cash, cars, a helicopter, all of this part of an investigation into theft, fraud and money laundering at the state-backed Astina dairy project in the Free State. Judge Loubser said the NPA's application for the asset freeze was marred by shortcomings. Now, for a look at what this development actually means, we're joined by a former judge and member of the Joburg Bar, Advocate Deon Pool. Good to see you, Advocate. Thanks so much for coming in. You know, I say this is a surprising judgment. When you heard this yesterday, was it surprising for you?
It was surprising for me as well. I just want to correct something. I have not been a former judge. I've been a former magistrate.
Thank you for correcting us.
Thank you.
We appreciate that.
Yes, but it was very surprising.
I mean, let's talk about the grounds behind this. I mean, was it foreseeable, or I suppose when Loubser said, "Listen, guys, there are so many shortcomings, we can't go ahead with this."
If we consider Judge Loubser's judgment, he was very adamant in the fact that the NPA had failed to connect the dots. Now, in respect of the application that was in front of him yesterday, all that the NPA needed to do was to convince the court that a conviction might follow. So it's a very low bar. And in order to establish that, the NPA needed to just give the judge an indication as to what the case actually amounts to, how they connect the dots, basically. The court doesn't have to decide whether it's true or not, or what the value of that evidence is, simply just to know that it is there and that they are able to present it.
Yeah.
And they, according to the judge, failed miserably in that attempt.
So let's talk about the consequences of all of this now, because obviously allowing the Gupta resources back into the hands of the companies owned by this family gives them much more power now. We're talking 250 million rand.
Well, on the one hand, it does give them back their assets, which were initially preserved. And on the other hand, it now leaves the state in a bit of a conundrum, because even if a conviction should follow, they might not be able to lay claim to all of these assets again. Because the main consideration in Judge Loubser's judgment was that the money that was paid from Astina to the Bank of Baroda had intermingled with other funds in the so-called pool account. So the intermingling can now go even further, that at the end of the day we would not be able to actually preserve the 250 million that was paid from Astina over to the Bank of Baroda.
What does this mean for the family? I mean, I imagine this is a major victory for the Guptas.
It is a major victory, yes, because in respect of all of these matters, the state applies for preservation and confiscation orders very early on in a proceeding. That's before the trial has started. There must just be an intention to institute the trial. So at this point in time, they are, and I have to admit, would be laughing in their sleeve.
Which is worrisome. It's very, very worrisome, because in August we're seeing the state capture case coming up. We're seeing the inquiry and the hearings into this, and a criminal case from the NPA. But the NPA is saying, you know, it's a little setback, but they're still very, very confident. However, during the judgment yesterday, I mean, it was very difficult to think that optimism should be a part of their modus operandi, because basically being said that the court finding that it was not reasonable to believe that a criminal case against the accused for theft, fraud and money laundering would one day actually succeed.
No, that's precisely what the judge said. And considering the fact that the NPA had brought a similar application in front of a Judge Jordan on a previous occasion, who also dismissed it, premised on the fact that there was no evidence presented to him that indicated that any of this money found its way into the Gupta-linked accounts. So they knew before they went to Judge Loubser where their shortcomings lay in their application, and it appears that they did absolutely nothing to rectify that.
Yeah.
Similarly, also, you will notice that Judge Loubser specifically meant that part of the application was missing. He said that the Baroda statements were never supplied to him, as well as Judge Jordan's statement was never supplied, Judge Jordan's judgment, rather, was never supplied to him. So in this instance, they actually took away from this judge's consideration material aspects in respect of this application.
So let me understand this correctly, because we all know this is surrounding the Astina dairy project. the Gupta leak emails have come out and in hard evidence shown that the family benefited immensely from this. The money landed up in their bank accounts. And yet, where we say that there isn't enough evidence. So what's happened? I mean, what's happening behind the scenes that perhaps we need to understand? Obviously, this has been going on for a long time. Are we seeing the destruction of a lot of evidence that can actually hold the family to account?
Deon, I won't go so far as to say that there's been a destruction of evidence. One thing that I did find, however, surprising or concerning is that the application for preservation and confiscation orders happens in secret. It's a secret process. It's with the judge in chambers. It's done as what they call to as ex parte, in other words, without the party. And the judge makes that order. The first time you know that there's a preservation order going is when they arrive at your house to lay claim to your assets. In this specific instance, the NPA actually advertised the fact that they were applying and were going to lay claim to these assets. And I found that very concerning.
Okay.
The second aspect that I want to mention is that in consequence of what happened yesterday and the judge's views on this, there is a question mark in my mind as to how serious the NPA is actually taking this. Because I've dealt with preservation and confiscation orders that have been watertight. You can attempt to oppose them as much as you want to. They are absolutely watertight. And considering the onus that there is, the low bar that there is to convince a judge to keep it in place, I find it very surprising that the NPA has missed the mark on this one.
Yeah, yeah. So where to from here? I mean, what is Judge Loubser's actual game plan? Does he have a game plan? I mean, can we read into anything going forward?
No, I don't think Judge Loubser specifically has a game plan. He's bound to the papers that were in front of him. He had to adjudicate the matter that was in court. This doesn't detract from the fact that the NPA can still pursue the charges. And hopefully, considering the two judges have now technically told them, look, these are the gaps in your case. You need to go and fill them. We know this evidence exists. And we know that if the evidence is presented properly, that a conviction at the end of the day could possibly follow. The most important aspect here is the intermingling of funds between payments made to the Baroda Bank and from Baroda Bank to various entities. And that is a very easy solve as far as I'm concerned. And I'm sure that the NPA, they do have the evidence that is required to prosecute this case properly. And we can only assume that the game plan might be is that the evidence necessary to have a conviction follow would come out in the trial, which I am under correction, which starts in August.
Yeah. Look, my last question to you is, what do the NPA need to do to strengthen their case? Because I think we got a very, very strong indication from Loubser yesterday that the quality of the state's case is not good enough to actually get any convictions at this point.
I think the view that we must rather take is that the quality of the evidence is there. The fact that it wasn't included in the application before Loubser is not an indication that it doesn't exist or that it's not strong enough. In Loubser's application, he specifically indicated that you have not told me how you are going to achieve a conviction. So that was left out of the application. Now, on the one hand, it might be strategy to do that in order not to alert the accused as to what it is that you have, that you are wanting to present, so that they can prepare themselves accordingly. On the other hand, quite possibly, the evidence has just not been collated properly, and the docket has not been properly prepared, and that is why it was not included in the application.
All right, let's leave it there. Let's see what happens going forward. Advocate Deon Pool just helping us connect the dots in a case that is far from over in relation to corruption charges against the Gupta family and related companies in the Astina dairy farm probe. But at this point, if we were scoring, I would definitely say Gupta's 1, state 0. Let's see what happens going forward. All right, let us take a break here on the